Actually, I think I just started. I've been talking for 20 minutes and I didn't have the camera running. That is freaking embarrassing. Okay, today we are talking about medical marijuana, the impending issue of if you are dealing with a juvenile court. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Now, if you're dealing with a juvenile court, that means that you are either a juvenile or you have a child that has been taken into care. If you have a child that's taken into care and you have a medical marijuana card, what is that going to mean for you? Well, it means you have a medical marijuana card and you're probably still going to be banned from using marijuana. So, not legally, you're not going to be thrown in jail for, they're not going to take your medical marijuana card away from you. But if you test positive, and presumably you will if you have a medical marijuana card, then you have a bigger issue with the juvenile court. We're going to talk about that more here in just a moment. So if the juvenile court orders you to not use marijuana, and you respond, but I have a medical marijuana card, what's going to happen? Well, the first step to understand is, first, you don't have a prescription to use marijuana. And if you don't have a prescription, then you don't have the protection of a prescription. So the court is able to say you cannot use that substance. It is illegal. And it is illegal on a federal basis. There are courts in Missouri that have already discussed this and decided that their standing policy is going to be no. You can't use it. That's going to be the policies here in Northeast Missouri for a lot of people. So if you have that medical marijuana card and the court tells you you cannot have medical marijuana, you are falling into an interesting gray area. That has not been litigated. I'm going to tell you, as a lawyer that practices in this area all the time, it is not worth losing your kids over. Get your kids back, move to a more enlightened area of the state, and resume your use of medical marijuana. Do not parent under the influence. So the legality is in question. You're going to have different standards in different parts of the state, and that's not cool. It's reality. Over near Kansas City, you very likely are not going to have a problem. You have a medical marijuana card, as long as you're not parenting under the influence. They're probably not going to take your kid, or they will work with you to get your child back to you. If you are in another area of the state that takes a harder view on drugs, you could well be facing termination of parental rights by the end of the process, unless you cease using medical marijuana. Now, yes, that's an appealable case. We can get into court of appeals. We can take it up. We can raise the issue, and we can argue it. But by God, that's a serious, serious case to risk. And if there are other grounds for them to terminate, they'll terminate on those grounds. And the court will never reach a decision on medical marijuana. So understand that it's not a cut and dry issue. It is actually a very questionable issue. Now, because everyone's going to point to it and say, well, what about the Constitution? What about the amendment? And, where in the statutes is what you're talking about? We're going to come back to that here in just a second. Starting with the Constitution, you understand that, Article 16, Section 1 is titled Right to Access Medical Marijuana. Now, this section is intended to permit state licensed physicians to recommend marijuana for medical purposes. Now, it also allows patients with qualifying conditions the right to freely discuss it, the right of the physicians to provide professional advice, and the right to use medical marijuana for treatment under the supervision of a physician. Now, that statement of purpose is an arguable point, that while there may not be a prescription for medical marijuana, our Constitution has enshrined a right to use it under the supervision of a physician. So, is the juvenile court going to be able to successfully take away your right to use medical marijuana? We don't know yet. That's going to have to be tried. It's going to have to be argued in court. It's going to have to be argued up to the appellate court. Here's the issue. It is not an apples comparison with drinking. The court most certainly has a right to give you an order to not drink. Drinking is legal. You certainly have the ability to go out and drink. The question then is, drink alcohol. The question then is, do you have a right to drink? I don't know. On one hand, the libertarian in me says, yes, you've got a right to it because there's nothing that the government has prescribing that right. However, it's not expressly listed as a right, the right to consume alcohol. The right to access marijuana, the right to use medical marijuana, is expressly listed in the Missouri State Constitution. So that right may actually trump the juvenile court, which is going to be an interesting argument. Matter of fact, I'm looking forward to making it in the case. So I don't expect we'll be successful, but I'm looking forward to making it. Right there at the beginning of the constitutional amendment. So when we talk about that, we are talking about a completely unsettled area of law. I've said it before in other videos. I'm going to say it again. You don't want to be the first. The first person is a ballsy person or an idiot. Okay? Either doing it deliberately to get their case in and heard, or they didn't pay attention to what was going on, and that's all they got left. So when you're looking at that and you're thinking, well, I want to take it up, the problem is by the time you get to the Court of Appeals, you've most likely, you're having some serious issues with juvenile court. Probably termination of parental rights. So, is the judge's order to abstain from certain substances, marijuana, alcohol, a final order that is subject to appeal? I don't think so. The adjudication, if you are adjudicated abusive or neglectful solely because you consume marijuana, I think that is appealable. And I think if you have a medical marijuana card and you appeal that, you probably have a good chance. However, now if you have a medical marijuana card, but the allegation is that you were parenting under the influence, that's a different issue. Now the question isn't, were you abusive or neglectful merely because you consume marijuana, but were you neglectful because you failed to provide proper supervision for your children while you were under the influence of that controlled substance? It's not a question of you're using the substance, it's a question of your conduct while you were using the substance. And those are different things. So we've got to find the right case to take up, or we risk making bad law. So when it comes down and you're looking at it, there may also be a very reasonable argument that the differences in circuit court circuits among the state, and the difference in the implementation of the rules creates unequal applications of the law. That's going to be a harder case because you're going to have to survey and produce data that shows that this is being presented unequally. And in juvenile cases, they're confidential. It's going to be hard to collect that data. So there's not really going to be a good chance to make that argument easily. It's going to be an expensive argument. It's the kind of argument you make if your parental rights have been terminated and you have nothing else. That said, man, the medical marijuana card is not a complete, the state can't do anything if I smoke marijuana. I'm fortunate. My particular brand of addiction is socially acceptable. They're not going to take my kids because I drink a 12-pack of Diet Coke a day. They are, however, perfectly within the ability, if I'm in juvenile court, because my kids are taken into care, to want to remove certain substances that may be affecting mental health. It might be the fact that, I take Sudafed a couple times a day because of an old broken nose. It might be the fact that I, do X, Y, and Z. Maybe I've got bad knees. I do. And maybe I've got a prescription for Vicodin. I don't. But the court could say, we want you to talk to your doctor and find another avenue. And we need to get you off of that substance because that substance is part of your problem. And the court is well within its authority to do that. It's not pleasant, but it's correct. So, 12 minutes for your medical marijuana card is not going to be an all-access pass or get out of jail free card if you're in a juvenile court or a drug court. That's the second part. We talked about juvenile courts. Drug courts are pretty much the same. A drug court can cut you off from certain prescription medications because they are addressing the addictive behavior, not the addiction to a specific substance. And if I was in drug court, they very well might say, Pat, we're cutting you off, no more Diet Coke. They could very well say no more smoking cigarettes. They're addressing the addictive behavior as much as the substance that the person is addicted to. Because a lot of people will simply change their addiction. They'll move from meth to cigarettes while they're in drug court. They'll move from one substance to another. They'll move from an illegal drug to abusing a legal drug because they think they can get away with it. So that's why drug courts will have a little bit more leeway that way in saying, no, you're not going to do that. And the alternative, what they're ultimately able to do is kick you out of the drug court. And then chances are, if you're in drug court, it's part of a plea agreement or a diversion if it's family drug court to avoid having your kids taken. So if you were kicked out of drug court, you could very well find yourself having your probation revoked and being sent to prison. Or if you fail out of family drug court, you could very well find your children taken into care. And then you're here talking to me on this video about you've got a medical marijuana card and they took your kids. So just because you have a medical marijuana card does not mean that you will always be able to use medical marijuana in Missouri. The courts are going to be able to influence that under certain conditions. So be smart, protect yourself, protect your kids. Go ahead, hit the like, subscribe, smash on that alert button so you know when we post a new video. And we've got a couple more that will be coming out really quickly. It's been a crazy week after I was out of town at the Solo and Small Firm Conference. We got back, it's just been insane, but good insane. So anyway, thank you very much, and I look forward to talking to you again.